right, Mr. Curtis, you have reserved 5 minutes for rebuttal. You'll open with your 15-minute presentation, and you may begin.
Great. Thank you, Your Honor. Good morning. May it please the Court. Aaron Curtis on behalf of Appellant Ross Dress for Less. The only question before you in this case is whether there was an accord and satisfaction. And the answer to that question is no for two reasons. First, there was no pre-existing dispute, and second, there was no unmistakable communication. Now, I'd like to start with the pre-existing dispute requirement for a moment, because that really is the most straightforward way of resolving this appeal. There was absolutely no evidence in the record that there was ever a dispute between parties over MLDev's tax obligations when the parties signed the agreement transferring the drainage easement. And accord and satisfaction is an affirmative defense, so MLDev bore the burden of proving all of the elements of its defense, including the existence of a pre-existing dispute. But nonetheless, MLDev didn't put forward any evidence. In fact, the record showed that the parties never even discussed MLDev's taxes before signing the drainage easement agreement, let alone disputed the question. And so, to provide a little context on this as well, the purpose of the pre-existing dispute requirement in an accord and satisfaction defense is to ensure that both of the parties are on the same page. Because the risk of an unfair surprise in this type of circumstance is quite a bit greater than other contractual disputes. There's a very great risk that a party may accept what it believes to be a partial payment on a debt without realizing that the other party is offering that payment to satisfy the debt in its entirety. And the pre-existing dispute requirement helps put the party on notice that this payment is being offered to satisfy the entire debt, because it tells the other party that, or it tells the party accepting the payment that the debtor doesn't wish to pay the entire full sum of the debt. And so here, there was no dispute whatsoever, so Ross was never on notice, and it never knew that MLDev intended for this new agreement to satisfy the pre-existing or any pre-existing dispute, because there was none.
What were the disputes between the parties?
There really wasn't any dispute, Your Honor. There was a question of whether MLDev would grant an easement.
The drainage easement.
Yeah, but that wasn't a dispute. Everyone agreed that there was just a mistake, that Ross's engineer had drafted up these plans, had drawn these maps, had written these legal descriptions of what property would be included in the transaction, and there was a mistake that the engineer made. And so they went back and they asked for an easement, and MLDev agreed to provide it. So it really wasn't a dispute at all, even over that issue. But the key point is that even if there had been a dispute over that, that wouldn't be enough, because the pre-existing...
So it's the only evidence of a dispute, whether we use the word in quotes or not, is the email back from Mr. Magnus, I think is the gentleman's name. Is that correct? Or are there any other documents or evidence showing some sort of disagreement about anything?
No, there really aren't. I mean, I don't know that email even shows that there was a dispute.
It's kind of a short and
sweet,
direct and blunt email, but
yes.
Is that the only documentary evidence of some type of disagreement that's being relied upon in this case?
I believe so. I mean, there's the declaration from Mr. Getz in which he describes his mistake and the fact that he went to Mr. Magnus asking for the easement, but again, I don't think that shows any kind of dispute. It just indicates that WGA, the engineering firm, had made a mistake and that they were trying to correct that for their client. And so,
did he ever decline and say, oh, no, that wasn't part of our agreement and that's separate and apart and we're going to have to talk about this because this is going to be a burden to the property?
There's no evidence that ever happened, no, Your Honor. There was really no evidence of any discussions, really, whatsoever, Judge Engelhardt. Mm-hmm. They said, I mean, Ryan Getz's declaration is quite brief. He just indicates that he went and asked for this, and Mr. Magnus responded that he was doing this as a one-time personal favor, and ML
Don't
or
come back.
Ross shouldn't ask for anything more. That's correct, yes.
Would the drainage easement purchase, I think it was what, $8,000? Is that the cost for the drainage easement?
It would have cost about $7,800, Judge Barksdale, if they had purchased it outright, if they had
Right.
included it in the original transaction.
So did the granting of the easement increase ML's tax obligation in any amount?
Did it increase?
Yes, sir.
No, it didn't. The drainage easement didn't affect their tax obligations at all, to my knowledge. MLDev continued to own the property. It wasn't that it was selling the property to Ross. It was just providing a small easement so that Ross could build this drainage ditch that would connect the two portions of the property, and the tax obligations remained unchanged by that agreement, because it really had no effect on the taxes and on those tax obligations. And so based on the lack of a pre-existing dispute, you can basically just say, case closed, we reverse and remand on this basis, and that's all you need to do. But if you want to, for some reason, reach what I would say more difficult question of whether there was an unmistakable communication, there's also no evidence that there was ever an unmistakable communication. And again, the purpose of this requirement is to ensure that both parties are on the same page, because again, when you have a situation like this where you have one party who's trying to tender a lesser payment to satisfy a greater debt, there's a chance that the party may accept it, not realize what's happening, and never realize that they are disputing this issue, or that the party is offering the payment to satisfy the full debt. And so accord and satisfaction requires that the parties be very explicit and very clear that what they are doing is satisfying the full debt with a partial payment. And here again, there's no evidence in the record that this communication or this agreement was sufficient to meet that high bar under Texas law. And
so other than the provision in the original PSA on the rollback taxes, is there any communication between the parties about the tax obligations?
there was an email way back before they were signing the PSA where they discussed the taxes very briefly and agreed that they were going to prorate them and basically reaffirm what their obligations would be under the statutory scheme. But it was a very brief email. There wasn't a ton of discussion, and that was the extent of the discussion.
And that's before the agreement, the purchase agreement?
That was before the purchase.
So after the purchase agreement, there's no discussion between the parties about who's going to pay what as to the property taxes? That's
correct. There's no evidence in the record that they ever discussed taxes at all between the signing of the purchase agreement and after, well, shortly before we sued them for their breach and their unjust enrichment.
So why is the unmistakable communication prong more difficult? It strikes me that's equally missing. I'm not sure.
I mean, I agree with you, Judge Oldham. We don't think that there's any evidence here that prong was satisfied either. I think the difficulty is perhaps in the fact that this is a very confusingly drafted provision, and there's a little bit of ambiguity there, perhaps. But the drainage easement itself is clearly an agreement that relates to drainage and easement issues, and all of the textual clues in that agreement indicate that.
Oh, you mean the email that says I'm releasing myself from all moral, ethical, contractual obligations now and forever into eternity. That could constitute, I guess that's what Judge Rosenthal said.
Yes, that was the basis of Judge Rosenthal's decision. She didn't consider the dispute requirement, which is, as I say, a totally independent basis for reversing and remanding here, but she based her decision entirely on paragraph 9 of the drainage easement agreement, which was this agreement that they signed, which, if you look at the document itself, all of the textual clues indicate to us that it has nothing to do with taxes. I mean, the name of the document is the drainage easement, and it has a provision that says that this easement is granted pursuant to the following reservations, terms, conditions, etc. And all of the provisions in the agreement relate to drainage issues and easements. There's never any mention of taxes whatsoever in the agreement. And there's never any discussion of obligations to third parties either. And here, the taxes that MLDev owed to Waller County were not an obligation owed to Ross, they were an obligation to the county. And so there was nothing in the agreement saying that Ross was going to assume MLDev's obligations to pay Waller County its taxes. There's nothing about that at all.
Can we pause on that last point? Because why did Ross pay the call it $500,000 property tax if it, I sort of assumed that the way it worked was that Ross was on the hook for the full tax amount and that it effectively had contracted to get reimbursed for the $500,000 on the rollback deal. But are you saying that Waller County had a right to that tax payment from MLDev independent of the relationship?
That's correct. Actually, it's the exact opposite of what you just said, Judge Oldham. It was that MLDev, in the first instance, was responsible, personally liable for all of the taxes because the owner on January 1st, under Texas law, is responsible for all of the taxes that accrue during that year. And the parties can change that. And they did that in that Ross actually contractually agreed to take on a portion of those taxes that it wasn't otherwise liable for under the default rule. But otherwise, the statutory system was left entirely in place the way it would normally operate, and this contract just, or the purchase agreement just reaffirmed that that was the position that they would be taking here. So, so to the question of whether MLDev, or why, I think your question was, why Ross paid these taxes in the first place, was because although it was not personally liable for these taxes and MLDev owed them, the government could have put a lien on the property if Ross had not paid the taxes for an extended period of time, and there was already interest and penalties that were starting to accrue on the property. And so in the interest of avoiding that pretty major harm on a development that it had made a huge investment in, Ross went ahead and paid the taxes and then sent the bill to MLDev, which it understood to be how this was going to proceed, both under the statutory scheme and under their contractual reaffirmation of that.
When Ross's legal counsel was looking at the release language from MLDev, what was Ross's understanding of all of that language, moral, ethical, contractual, now and forever? What was the understanding on your side of the transaction as to what that was supposed to be disclaiming?
If you look at the email in which they discuss it, it's brief, but again, it indicates that they say, are you sure that the BKDD isn't going to ask for anything else? And the BKDD was the local drainage authority for the Brookshire-Katy drainage district. And so it was clear that they were focused on drainage issues and easements, and those were the issues that had given rise to this agreement in the first place. So they were focused on trying to figure out if there was anything else that they were going to be precluded from asking MLDev for because they had signed this agreement. But they never discussed taxes, and you would think that if they thought that they were giving up the right to have MLDev pay $546,000 in taxes, they would have said something about that with their attorneys before they signed the agreement, and there's no evidence that they did that. There's also testimony from Mr. Burney, who was the representative of Ross, that he didn't understand it as relating to anything other than drainage issues, and so that also reaffirms their understanding that this was all just about drainage and easements and things of that nature. And it made sense because the parties had had quite a few disputes over easements already. There had been an easement a few months earlier. They're currently involved in easement litigation in 3 other courts, actually, relating to an easement that MLDev granted to Waller County. So easements was a long-standing issue for which there was a need to resolve this.
Is there anything in the summary judgment record explaining this Magnus email about I'm doing this as a one-time personal favor to you? I want to know is where he says we are now even. Is there anything in the summary judgment record concerning what he meant? Had there been a previous dispute, et cetera, that he thought this meant that they'd granted something to ML Dev, and now we're now even. I'm granting you this drainage easement.
Well, there's not great testimony, to be fair. He was asked about this during his deposition, and he gave a fairly unclear answer of why he said what he said, if I may finish, Your Honor. But it was clear that Mr. Magnus did understand that, or did at least seem to be under the impression that he owed something to Ross, and that he needed to kind of get them on equal footing, at least with Mr. Getz. And I think part of that was that it related to this previous temporary easement that had been granted, where they needed access to the piece of property where they were building the drainage facilities, and so they had granted an easement for that purpose, and there was this other easement that MLDev had granted to Waller County that has also been litigated. So I think he felt that there was some need to kind of fulfill a contractual, moral, or ethical obligation, and he saw this as sort of the final thing that was going to happen in that process.
All right, thank you, Mr. Curtis. You have 5 minutes for rebuttal.
Thank you, Your Honor.
Let's hear from Ms. Hataway-Cone.
Good morning, Your Honors. Misty Hataway-Cone, counsel for Applee NL Dev. I had this
Ma'am,
nice.
What is the, just so we've got this on the record tape here, what is the document on which you rely for the accord and satisfaction?
That would,
Go ahead.
I'm sorry, Your Honor. That would be paragraph 9 of the August 2019 drainage easement agreement, which was the culmination of a series of 6 agreements that these parties entered into. One of the issues that, Your Honor, Judge Oldham raised was, were there any other disputes? And I think, Judge Engelhardt, you did as well. There were a series of disputes and ongoing contractual amendments and negotiations to really get to the final bottom line. And what's important for the court to acknowledge is that—
Are those in the record? I hate to interrupt. Are those in the record? Okay.
They are, Your Honor. You'll see that those 5 contracts, that there were negotiations that occurred that required the First Amendment. And then
Not just the contracts, but the actual disputes, and I guess to put a finer point on it, a dispute over the tax burden.
So, Your Honor, to be clear, I'm not certain that the case law requires that the specific dispute at issue be the subject matter of the accord. There need only be a dispute between the parties that satisfies the consideration for the accord and thus the satisfaction. I believe and that appellant is taking a very limited, restrictive view of the case law and the requirements of the case law of what the dispute has to be. My reading of the case law from this circuit and the district courts, as well as Texas state law, is that a dispute can occur separate and apart from the subject matter of the consideration, and this accord and satisfaction resolves all of it. And so it doesn't necessarily have to be a dispute about the payment of the taxes. There need only be a dispute between the parties. And so I would ask the court to look at its case law and its precedent, and you'll find that the limited view that the appellant is taking in this matter before the court is not supported by precedent.
And which precedent exactly are you relying on?
Your Honor, the Texas Supreme Court opinions in Baylor, as well as the Pulsifer case, those are 2 cases that are fairly directly on point, where you had broad language like we have here in paragraph 9. In both of those cases, the contracts were drafted by attorneys rather than a layman. But you see broad language that kind of is a catch-all that covers everything. And in those instances, the Houston Court of Appeals, I believe it was the 1st District, as well as the Texas Supreme Court, found that those, even though there was that broad language, that it was unmistakable, that there was in fact a dispute, and this unmistakable communication was sufficient to constitute an accord and satisfaction.
And how many disputes were there in Baylor?
Well, Your Honor, I believe that appellant points to one single email as being a dispute relative to the taxes. I think he also mentioned that there's other cases and lawsuits between these parties. There is, in fact, a number of heated discussions that led to those subsequent amendments to the contract from the original PSA that actually contractually allocated the obligation of the payment of the rollback taxes, so that while statutory was codified in the parties' agreement, in the very first agreement, then there were two subsequent amendments that referenced additional taxes that were either allocated or assumed by the parties. And then you actually have the tax proration agreement, which was entered in May 17th of 19, the very day of closing. So the timeline is really important for the court to acknowledge as well, Judge Oldham, because you'll see that this paragraph 9 in the drainage easement occurred after all contractual obligations other than the payment of rollback taxes had been satisfied.
I understand. It can be back up for just a minute.
Of course.
You offered me Baylor as your best case, and my question is, in that case, as opposed to this one, how many disputes were there between the parties for which the broad release and the accord and satisfaction would be sufficient?
I believe in Baylor it had to do, there was one singular dispute.
Exactly. So
There was one singular.
So what would be your case where there were two different disputes sufficient that one accord and satisfaction would satisfy both? Because I've tried to read your cases, and you point out, oh, Texas precedent, this and that and another. But I don't see any of these cases where there are cases that have broad release language, like the one that your client drafted here. But it would always, everyone knew what the dispute was because there was only one dispute between the parties, as in Baylor. Here I understand the broad release language applies to two different contractual issues. One is about drainage. Clearly, everyone agrees we were talking about drainage. And then there's a second question about $500,000 in rollback taxes, and you want to use one accord and satisfaction to satisfy both. And I haven't seen a case yet. Maybe you can point me to one.
Well, Your Honor, I don't know in my review of cases that there is a case directly on point where you have multiple disputes, nor is there case law where the dispute is limited to the very subject matter first.
Well, let me ask you this way. What would be the best document in the record in this case where your client said, we think we should pay nothing for the $500 and some odd thousand in the rollback taxes?
I think the drainage easement itself, because it was executed after all contractual obligations were satisfied between the parties, is that best evidence, Your Honor. Because
The drainage easement itself.
Yes, Your Honor. Because at that moment in time, all the money had exchanged hands, the property had been conveyed, and it was a year post-closing. So the only thing that remained unpaid, the only contractual obligation that remained in existence between the parties that hadn't been satisfied was the payment of rollback taxes.
And what would be the text in the drainage agreement that references the property tax liability?
There isn't a specific reference, Your Honor, but the case law doesn't require that there be a specific reference. Both this court and the Texas Supreme Court are clear that you don't have to specifically reference the contract which you are according, that the contract that you are satisfying and amending effectively. That specific reference is required, although that is the position that appellant is taking in the time before the court. That we can look at the language and we can look at the context, although you're not required to look at the context because this isn't resting in implication, is in fact a written agreement. But Your Honor can look at the actual language and you can look at the timeline. Okay, well, if your court is supposed to give meaning to every single word of a contract, which is black letter law and has been since the creation of court, I mean, it's what we learned the first day of law school. If you are supposed to give impact and effect to every word of a contract, how does this paragraph 9 operate absent relieving ML Development of its contractual obligation to pay those rollback taxes?
So how far are you willing to go with that? Because it says that it's also releasing ML Dev of future contractual obligations. So is your view that you could enter into a subsequent contract with Ross, maybe for another drainage easement, maybe for another parcel of property, who knows? And you would say, well, hold on a second, I've released myself from my future contractual obligations too. Or if I have to give effect to every single word in there?
I think, Your Honor, we have to give effect to every single word in there, but when we look at paragraph 9 and we look at, unlike a typical release language, which has the known and unknown, existing, not existing, we don't have that kind of open-ended. We just have the conveyance fulfills any and all contractual, moral, or ethical obligations they've had in the past or in the future relative to this easement, right? And so, and the right-of-way.
Hold on a second. If it's relative to this easement, then haven't you just given up the case?
No, actually, I haven't, Your Honor, because when we read the rest of the clause, it says, Dev LP shall have no obligation to provide any easements, right-of-way, or anything else of value to grantee. So it is tied, this is the final conclusion and the final chapter of these negotiations and contracts between the parties. And we have this agreement between the parties. A layman admittedly drafted this, but Ross Defense Counsel at that time, they absolutely looked at it and they approved it. And when we look here, it isn't as open as Your Honor is concerned, although I recognize that. I do recognize that concern. But when we look at the simple plain language, we see that it isn't existing, not existing, known and unknown, like we typically see in a settlement release. It is, in fact, all contractual, moral, or ethical obligations that the two parties have between one another, and any duty of my client to provide, and this is the other categorized language that we have to look at, because I believe the focus has been on the beginning of paragraph 9, and we're ignoring the second part of paragraph 9, which is MLDAV shall have no obligation to provide any easements, right-of-way, or anything else of value to the grantee.
That's the point. Again, this is a fairly inartfully drawn paragraph.
Yes.
But to provide any easements, right-of-way, or anything else of value to the grantee, well, they didn't owe the taxes to Ross, they owed them to the county.
We owed the obligation under the original PSA to pay those rollback taxes on behalf of Ross. That was the very first agreement, Your Honor. The very first agreement between the parties in the actual contract.
The difference between on behalf of and to.
Well, the language actually, I understand Your Honor's concern, because I think the argument that appellant is making is that this is simply a statutory duty, but we can contract around that statutory duty. That's well established, and appellant even acknowledged that.
We didn't clearly contract around that statutory duty.
No, but what we did was we simply said, we didn't include the language on behalf of, we said seller will pay all of these rollback taxes. That was the first agreement that was then the subject of 5 subsequent agreements. And so the PSA itself was amended 3 times. Then you have the tax proration agreement, and then you have this drainage easement. And so, Your Honor, it isn't merely, this isn't a simple, if that sentence wasn't there, if there wasn't paragraph 6 in the PSA for the proration of taxes, I would absolutely be struggling here today. But I am not, because it became a contractual obligation to pay it, not on behalf of Ross, but to pay it. It then changed from simple the statutory imposed duty under the Texas Property Code to a contractual obligation. It was no longer paying on behalf of Ross, who was then the owner when the bill came due. It was, I am obligated to pay it. And that obligation existed throughout the First Amendment to the PSA, the Second Amendment to the PSA, the Third Amendment to the PSA, and even the tax proration agreement, which was the day of closing. It wasn't until there were no other obligations that existed between the parties, 1 year post-closing, that we have paragraph 9 in the drainage easement agreement.
You mentioned 2 cases that you are relying on. One was Baylor, and give me the name of the other. I couldn't write
It's
fast.
Paleco, or I'm from Texas, so please excuse if I can't pronounce this correctly. But Paleco, it is 735 Southwest.
Spell Paleco.
P-I-L-E-C-O.
Okay.
B-H-C-I.
And there's one dispute in Paleco, as there was in Baylor, right? It's a $5,700 dispute over one account. And the question is, in tendering the payment, have you satisfied the entire amount due minus the $231 in interest? And so there's no question between the parties about what they're fighting about, because there's just $5,700 at issue between them. And the question is, when you tender a check and it's deposited by the account holder, is that accord and satisfaction of the entire debt, or is there still this $231 delta? So again, it doesn't help, I think, with the question that we really have, which is, how do you get to a second obligation, namely property taxes in our case?
Respectfully, Your Honor, I believe that in Paleco there was that additional obligation to pay those interests, that at least the creditor believed that it was owed, and the creditor accepted the lesser payment of not paying the interest and fees in satisfaction for it. Here, the only contractual obligation that existed, the only thing that remained untied was these rollback taxes. And there was a dispute relative to that property and whether or not it should have originally been conveyed, and what's important is that to this very day, despite the fact that there's substantial litigation still remaining between the parties in Texas State Court and Waller County, that there's still no litigation between Ross and the very...
Wait, you can't, you're not just going outside the record, you're entering a whole new universe unless I'm missing something. You're talking about something that's happening today?
Your Honor, I was merely referencing to the point that appellant argued before the court, which is there's this litigation in Waller County. I'm not involved in that litigation. He made reference to it in his opening time before the court.
Now, and again, if it's in the record, is there anything in the record concerning why Ross would have accepted giving up the obligation of ML Development to pay $546,000 in taxes, why it would have accepted that in satisfaction of property worth $8,000?
Yes, Your Honor, and to be clear, there's the price value that was referenced during appellant's opening time. Maybe the mathematic answer to the value of that property, but the value itself was not the subject of anything in the trial court. That's simply a multiplication by, under the contract terms, of $285 for one parcel, per parcel, and then $305 for the other. So to be clear, the $8,000 isn't necessary. I will not agree that that's the value of the easement, number one. But there is evidence.
What is the value of the easement? Is there anything in the record supporting the value of the easement?
No, Your Honor, there isn't. It wasn't something that came up, other than simply taking the math of the square footage of the easement and multiplying it by the terms of the contract. But what is important for the court to be aware is that this...
What was that value? The square footage of the easement times the value of the square foot under the terms of the contract?
I'll be really honest, Your Honor. I'm here because I'm not a math major. I couldn't tell you that. And I'm going to be very honest. I can't tell you that. I have no reason to dispute that it's $8,000 because...
You're being really honest about everything here, Counsel.
I am, Your Honor. It's my duty of candor to the court.
Exactly. So you don't have to tell us that.
Okay.
We accept you're being honest.
I appreciate that. But the two things...
We also accept you can't do math, apparently.
Well, I apologize.
I'm not asking you to do math. I'm asking what's in the record.
There isn't anything in the record about the actual value, Your Honor. There isn't. But there is evidence of the other concern that you raised, which is the time value of getting the easement. They could not continue the development of this multi-million-dollar warehouse absent the ditch and the drainage easement. In addition, that drainage easement drains over across other property that ML Development owns that they cannot now sell for a marketable value of what it was before this drainage easement because this easement is now over it. And so there's
nothing in the record that's why ML Development thinks it doesn't owe $546,000 because they lost value on some of their other property later.
No, Your Honor. ML doesn't believe that it owes the $546,000 because they entered into an accord and satisfaction.
They would have owned it but for their claim that they have an accord and satisfaction.
They would have owned it at closing. They would have owned that obligation at closing to pay it post-closing.
Owed?
Yes.
Are you saying
contractually, they would have owed that payment because
$546,000.
$546,000. And then a year post-closing, before those bills became due, this dispute arose relative to the need to immediately acquire that drainage easement absent a long, detailed, complicated, expensive condemnation proceeding. And there's evidence in the record indicating the fact that Ross Development never even entertained the notion of doing a condemnation because of the cost and the length of delay. And that's why there was so much pressure put upon ML Dev to execute this. And so the language was then negotiated, and the language was drafted, and it was exchanged with Ross's legal counsel, which was blessed, and it was executed at the time that the only obligation that remained between the parties was that payment of those rollback taxes that existed contractually from day one. And that was all that remained, Your Honor. That was it. Now, the other thing I would like to ask the court to look at is the concern that this was an unmistakable communication. When we look at the plain language of paragraph 9, what else could it be? When you look at...
It could have been including paying the rollback taxes. We have no obligation to you to pay the rollback taxes. That could have been in it.
It absolutely could have, but the law doesn't require that it's specified.
Well, you asked what other language could there be. I'm telling you, it could have been to pay the rollback taxes.
Well, Your Honor, I asked, in my briefing and in the lower court proceeding, if my client is not released of the contractual, ethical, and moral obligations, if that doesn't refer to the only contractual obligation that remained between the parties, what else could that language relate to? And I've yet to see an answer. In fact, there is no answer presented by appellant in this court of what paragraph 9 could apply to if it did not apply to the contractual obligation of my client to pay those rollback taxes.
Well, your client drafted it, and so I'm curious, what were the moral and ethical obligations that you...
I think the moral and ethical obligations relate to my feisty clients saying, I'm going to do you this favor, and this is the last one.
But it's not much of a favor if they pay you $546,000 for it.
I think, and there is not evidence on the record for this, but when you look at the context for that email, I believe that the saving of the condemnation proceeding and the saving of the time is those ethical, moral obligations that my client gave up, a contested fight for the condemnation for them to obtain this drainage easement.
Well, it would have cost your client to, I mean, if what I'm understanding is that you're representing your client would have fought the condemnation proceeding.
I am not.
Oh, no, you're not. Well, then what would have been the fight? It wouldn't have been very costly at all.
I'm sorry, Your Honor. I thought you said that I'm representing my client in a condemnation proceeding.
Oh, I'm so sorry. I apologize for the audio. You're representing that your client would have contested the condemnation proceeding and presumably would have incurred legal fees and it all dragged out for your client as well.
Absolutely, and there is summary judgment evidence in the record for my client relative to that. That part of the kind of equation that went into this was the pressure to immediately provide this to save the length and time for a condemnation proceeding as well as the litigation fees. I see that my time is over. May I briefly conclude?
I think we have your argument.
Thank you, Your Honors. I really appreciate the time before the court.
Thank you very much. All right, Counsel, if you have 5 minutes of rebuttal time.
Thank you, Judge Engelhardt. I want to emphasize that this case just doesn't fit the accord and satisfaction framework. As you discussed, Judge Oldham and others, there's this case Paleko, which I think is actually kind of your quintessential accord and satisfaction case. The vast majority of these cases all involve checks. So the parties in those cases, one party clearly owes a debt to the other party, and the party says, hey, I don't want to pay this entire debt. And so then it writes a check, and it notates on the check that it doesn't want to pay the full debt. So it says something like, in full payment of all claims outstanding. And then the creditor cashes the check, and oftentimes they'll cross out the notation or they'll try to dispute it in some way. And Texas courts say, no, that's an accord and satisfaction. You are still held to that because you were on notice that this check was being offered to fulfill a disputed amount, a disputed debt, and case closed. That's all that you need to do here. But this case just doesn't fit that framework by any stretch of the imagination. Here, MLDev didn't owe anything to Ross. This wasn't a payment that MLDev was going to pay to Ross. It was a payment that MLDev was going to pay to the county. So here, Ross wasn't even a creditor, and MLDev was a debtor, but it was a debtor to Waller County. And so the government was the creditor, not Ross, and MLDev couldn't fulfill its obligations to the county by tendering a lesser payment to Ross. The only way to do this was for Ross to assume an obligation that MLDev owed to the county. And I'd like to talk a little bit about a couple of these things. My friend on the other side mentioned that there's no case law discussing whether the subject matter has to be the same. That just isn't the case. All of the case law indicates that the dispute is invariably with respect to the same subject matter as the payment that's tendered. And the reason for that is because the fact that you have a dispute over this issue puts the creditor on notice that the party that's offering the lesser payment is tendering it in order to satisfy the dispute. If they were two completely different things, as they're claiming here, one about the property that should have been included in the original agreement, which, again, we don't think there was actually a dispute about that, but if there's a dispute over that, and then the lesser payment is a discharge of tax obligations, that doesn't put you on notice that the lesser payment is meant to satisfy those tax obligations, because the two are just so different from one another that there's no relation. I'd also like to say that she mentioned the language of paragraph 9 and how that includes contractual, moral, ethical obligations. I think there are a lot of people who would say that tax obligations are an immoral obligation as opposed to a moral one. But the fact that I'm getting at here is that they were owed to Waller County. They were not owed to Ross. And so no matter how you read this agreement, it says twice to Ross, and then it later says to the grantee. And in both of those cases, this was not language or this was not an obligation that MLDev owed to Ross. It was an obligation that it owed to the county. And finally, I just want to note that we do give meaning to paragraph 9. On page 16 of our brief, we explained, of our reply brief that is, we explained specifically how we understood this paragraph to operate, and we, as I mentioned, we had previous discussions about easement, about drainage issues. There had been a lot of back and forth about this. I wouldn't say it was a dispute, but there was quite a bit of drama around these issues, and the parties just simply wanted to put all of that to rest and move forward and not continue to have these debates around easements, drainage, and things of that nature. So the text of the agreement, the surrounding circumstances, all of the evidence in the record clearly indicates that this was about drainage and easements and wasn't about taxes. And so unless you have any further questions, I'll ask you to reverse.
All right, thank you, Mr. Curtis. We have your arguments in this case, and the case
Well,
will...
let me just say this, since we have cross motions for summary judgment, you want us to reverse and render, don't you?
That's correct, Judge Barksdale. We think that there's no issue here, and the other side agreed that the only issue on the table is what paragraph 9 does, and so we think you can reverse and render.
All right.
Thank you, Your Honor.
Thank you, counsel. The case will be considered submitted at this time, and that concludes our oral arguments for today. The court will be in recess until 9 a.m. tomorrow morning. Thank you, counsel.